Now, Kim will talk about the tension between surveillance and privacy. She will actually question how information technology can have an impact on our life, and also how it can be used in positive and creative ways.
Thank you very much. Thank you very much for inviting me to participate today in this President's Conference series, and it's an honor to be here. My paper is comprised of three short sections that will address some of the concepts that are included in today's conference. In the first section, I will distinguish between paradigms of surveillance. In the second, I will describe some of the pertinent bits of law and policy. In part 3, I will conclude by returning to this question of privacy. Rather than declaring that the demise of privacy is an inevitable condition of the 21st century, I suggest instead that we need to continue to debate and to consider its ethical ends, hence the title of my paper. So what do we mean by surveillance when we say it? In what is undoubtedly one of the uber texts of surveillance studies, Michel Foucault's Surveiller et Punir, Foucault describes one modality of surveillance, the prison. In this image of surveillance and power, the guard sits in a central tower, observing the prisoners along the wall, unseen, while those incarcerated are visible and therefore vulnerable and compliant. As those working in surveillance studies have argued, panoptic power describes a classical architecture of the prison. It is an efficient and economical system because just one person can maintain control over a large number of people. Power here is essentially centralized in a single location, and the panopticon is most relevant, I think, as a description of active surveillance cameras in a watchtower guarding a particular social space. We arguably live in a situation that could be described as post-panoptic. In a post-panoptic context, there is a dispersal of power. It doesn't emerge from one location, but from a multiplicity of seeing eyes that are decentralized. The seer and the seen may both be subject to surveillance, simultaneously monitoring and monitored. Furthermore, the subjects are mobile and not caged. Cameras or listening devices are not invisible, but most likely used as a means of deterrence. Data may be captured, but most often it is not stored in archives for long periods of time. Examples of post-panoptic surveillance include CCTV cameras in buildings, radar traffics at intersections, webcams in home or streets, or my own favorite, the Tim Cam at the University of Toronto Mississauga campus directed at the lineup for coffee that you can look at on your computer monitor. These two classical models of panoptic surveillance have been supplemented, I think, by a new logic of surveillance characterized by their connection to electronic technologies and computational systems of data capturing and processing, data-veillance. David Lyon, amongst others, describes it as a new and distinct modality of surveillance. In data-veillance, visibility, disciplining, and deterrence are not pivotal. The capturing of information is. From the cradle to the grave, what is at issue is our inscription into systems of the numerical ascription encoded on credit cards, swipe cards, social insurance cards, in our web addresses, all that allow us to be traced and tracked and to leave a record of our comings and goings, as described this morning. These forms of data-veillance by governments, by corporations, and by thieves are not simply repressive. They are generative, operating under a rationale of assent and consent. Our assent to their conditions grants us the right to participate in institutions and systems, from healthcare to education to the marketplace. They create statistics from the crumbs of the cookies strewn across the data sphere, or the spywares that silently troll our hard drives and slow our life as data surfers to a crawl. Our habits and history of uses, both individual and collective, breed not merely individual data, but aggregate data that is collected to predict possible future movements. Data-veillance has become a condition of contemporary citizenship in networked societies. At their core is the practice of data mining. In this realm of commerce, this occurs through our registration on websites, our use of coupons, our entry into contests, and most importantly, through our credit cards. As Valerie Steve states, this form of online surveillance is not based on the collection of core biographical details. It is, in fact, the mundane information that emanates from online interactions that allows others to create detailed profiles of the online behavior of the people being watched. Surveillance as data capturing allows for greater customization or micro-target marketing to stimulate consumption. It aids in market expansion by selling third-party information about you. In this, you and your data are a new and very valuable commodity. Governments, too, engage in data-veillance through the scanning of passports at borders or the covert collection of information of particular populations of interest. The result in both instances are the creation of profiles of likely targets based on emergent patterns. It is at once impersonal, yet individuating when necessary. In the case of policing and criminal justice, the move is to the prevention of future crime rather than the capturing of criminals, in an eerie echo of Philip K. Dick's classic story, Minority Report. The main features of data-veillance include the relative invisibility of the system, its integration into our everyday lives. Its underlying goal, unlike the panoptic forms of power I described, is not deterrence, but information collection, prediction, and risk management. Its logic is one of necessary assent on the part of citizens who have no choice, but feel as if they do. Complicit surveillance is the fourth modality of surveillance. While related to data-veillance, with complicit surveillance, we participate in the realm of social relations rather than in politics and commerce, although they are, of course, related. Complicit surveillance is intrinsic to the participatory culture of Web 2.0, to social networking, to ubiquitous computing, and to our own longing for greater connectivity through telecommunications. In complicit surveillance, we desire to be discoverable. We willingly create profiles on Facebook or post our photos on Flickr to promote ourselves or our group's activities. We participate in the breaching of the boundaries of our own private lives by posting information in public space, not only through the web, and we are always on. We are accompanied by an ever-present, always with us handheld computing device, such as the cell phone, and through applications like Twitter. As my colleague Leslie Shade writes, such practices engender and encourage a compliant culture of friending and of self-disclosure that may have troublesome consequences. Such social networking sites are entered for the very purpose of seeing and being seen. Other Web 2.0 developments, such as mapping technologies like Google Mapping, predicated on the use of GPS satellites, also offer a prime example of complicit surveillance and the tensions it holds for us as individuals in relationship to our privacy. We want access to others' information, but simultaneously, we feel the breaches of our own rights to privacy when the Google truck takes a picture of our house on our street. Now, one of the disturbing things, for me at least, as a Canadian Studies scholar, about living in Canada is that quite often people will know more about policies and laws from the United States than their own country. When, for example, Canadians talk about security and surveillance, they will often mention the Patriot Act rather than our very own 2001 Anti-Terrorism Act, Bill C-36. At the risk of being completely dull, I want to list a few salient moments in legislation and policy that have been central, if relatively unknown, in their framing of issues germane to privacy and surveillance in Canadian law. Indeed, there have been a number of legislative efforts to protect us from unwanted interference by the government, from unfair business practices, and from crimes, but also from practices like phishing and lottery scams, as well as identity theft. The 1982 Charter of Rights and Freedoms, for example, defines fundamental freedoms, democratic rights, mobility rights, legal rights, equality rights, education, and of course, language. Key to debates on privacy and surveillance in this charter is the right to be secure against unreasonable search or seizure, Section 8, as well as Sections 9 and 10 that states we have the right not to be arbitrarily detained or imprisoned, and if we are arrested, to be informed of the reasons. This led, of course, to the 1983 Privacy Act and the establishment of the Office of the Privacy Commissioner. And finally, PIPEDA, also governed under the Privacy Commissioner, the Personal Information Protection and Electronic Documents Act, which has been in effect since the early 2000s and applies to the collection, use, and disclosure of personal information for the transaction of commercial activities. Indeed, it was the provisions of PIPEDA that provided the basis for the University of Ottawa law students to petition the Office of the Privacy Commissioner to investigate violations of privacy rights occurring on Facebook recently. On the other hand, there's also been important amendments to the criminal code in the past 20 years that affect the right to privacy and the abilities of those who have power to survey us. The most important of these is Bill C-109, passed in 1993, which amended provisions to the criminal code to establish 4 new types of warrants: the general warrant, the video warrant, the tracking warrant, and the number recorder warrant. That also amended wiretapping provisions. This bill was aimed to clarify police powers under electronic surveillance because prior to this law, the Supreme Court ruled that the use of electronic surveillance devices by police without proper prior judicial authorization was a violation of Section 8 of the Charter. With Bill C-109, the government effectively eliminated the need for Parliament to legislate on each specific device pertinent to police investigation. And the warrant was a step to promote the enforcement of community security over the promotion of individual privacy. What was left out, however, was a proviso that stated that general warrants could not be attained if they would interfere with the bodily integrity of a person. The general warrant, as well as the amendments to the criminal code governing police powers to test for things like drinking and driving, combined, as Neil Gerlach has so cogently argued, to create a new legal context for us, one that is conducive to enhancing the power of the state to search and seize materials from a citizen's body, including blood and DNA samples. This increasing trend to surveillance to prevent future crimes because of a fear of crime and acceptance of the inevitability of surveillance intensified with 9/11. In 2001, in response to the events of 9/11, the government passed the Anti-Terrorism Bill, an act that was fundamentally incompatible with the privacy protections of Section 8 of the Charter, yet passed partly due to the fears surrounding terrorism. The Anti-Terrorism Act served to extend the state's powers again, giving the police wide, sweeping abilities to act on suspected acts, allowed for the detaining of subjects without charge for up to 3 days, made it easier for the installation of electronic surveillance, which was previously seen as a last resort, allowed for what is known as preventative arrests, allowed for judges to compel witnesses to give evidence during investigations, and for the designation of groups as terrorists. It made it a crime to collect or provide funds that would aid terrorism, to instruct anyone to carry out such an act, or to harbor and conceal someone labeled as such. And while there are important checks and balances in the Act, which was recently reviewed, part of the problem is that the original clause defined a terrorist act vaguely as one committed for a political, religious, or ideological purpose, cause, or objective or cause, and that's a quote. So, what has been going on here is a shift from an emphasis on criminal intent and due legal process to the management of potential threat, bypassing some of the rights we've been accustomed to in terms of fair trial. Indeed, this has been augmented as well by the creation of things like no-fly lists and security certificates by the Department of Immigration. And while I do think that preventative measures need to be taken to ensure that violent criminals do not enter the country or harm us as individuals, under this new regime of governance, citizens seem to already be presumed to be guilty and must prove their innocence rather than the other way around. However, important to remember is that information gathered through intelligence is not evidence that is necessarily valid in a court of law for the very reason that it's not subject to the built-in procedural assurances of reliability that we expect in the law. The ability to cross-examine witnesses, full disclosure to the defense so they can investigate the evidence gathered, and the ability to demonstrate the falsity of claims. And lest you think this is merely an academic argument or just theoretical hooey, or that I'm crying wolf, I point you to the ongoing case against Hassan Diab, a Lebanese-Canadian citizen and former sociology professor at Carleton University, who the French government is still trying to extradite and to bring to trial for his alleged role in the 1980 bombing of a synagogue in Paris. Diab has not been charged with anything, and there is as yet insufficient evidence to extradite him. Yet, he was fired from his job by Carleton University's administration in July of this year after he was already teaching. Not only was this a clear violation of his collective agreement, but as others have argued, it is tied to a larger trend towards risk management by institutions concerned with their public image and a change in criminal justice. Detained for 4.5 months, he was finally allowed bail at $290,000 under the condition that he wear an electronic GPS-enhanced bracelet. He cannot leave his house unaccompanied or have a cell phone, and he has paid thousands of dollars in legal fees. Why was he charged? Well, for one, Hassan Diab bears the same common Lebanese name of someone identified by the Stasi who supplied intelligence to the French police, who would like to bring him or someone to trial in France. Hassan has been condemned to a form of imprisonment without trial in the name of detention and public security. His case points to the trend I've been talking about in public security in the wake of 9/11, in which Muslim men in particular have become the subject of racial profiling and the replacement of open trials with new forms of detention under the rubric of global security. These policies, laws, and practices are all intertwined, and legal scholars and experts are engaged in endless, complicated debates on not only what laws, but what principles and values should take precedent. The individual right to bodily integrity, a citizen's right to free speech, to dissent, the consumer's right to privacy and protection, a community's contention that security and safety are paramount, or the assertion of those advocating for social justice that democracy and freedom of expression are values potentially in peril in this new context of increased surveillance in the name of public safety. They have a bearing on our lives as individuals and as a collective. And while there have been some responsible media coverage, there's also been some notable trends. In a study of 10 English language newspapers over a 6-year period, Josh Greenberg and Sean Heyer found that when CCTV surveillance is discussed, for instance, that important distinctions are often lost, such as the distinction between public spaces, such as streets and downtown cores, which are often conflated with private spaces used by the public, such as banks and malls. Evidence that CCTV surveillance is only effective in protecting property rather than preventing harm to individuals is rarely mentioned. The coverage of CCTV cams tends to be episodic, based on the occurrence of specific events that trigger a momentary interest. And finally, privacy issues tend to be under-discussed and jettisoned as irrelevant. Yet, I would argue, privacy is still a relevant concept, particularly if it is considered alongside the issues of democracy and social and criminal justice. Privacy can be thought of in terms of individual terms as solitude, as anonymity, as intimacy, and reserve. But its privacy, ironically, is also a social or a public issue if, as Valerie Steeves argues, we consider it as an essential facet of democratic process, as a social value in terms of data protection, and as a human right. As Gus Hossain adds, A regard for privacy is a belief that we must maintain human dignity and that this is the core objective of human rights. And as my preliminary research with senior citizens who must deal with an increased monitoring of their life by concerned family members also indicates, privacy is related to issues of agency at all stages of our existence as social and as human beings. The title of this series is suggests that we may be at the end of privacy. But as I've suggested, in the current context of data-veillance, risk management, compliance surveillance, and legislative changes to the criminal justice system, the ends of privacy should continue to warrant our attention. If not, then we're at the peril of destroying the very thing we seek to preserve through security and surveillance, the premises of our legal system and this process we call democracy. In closing, instead of humming the police's song, "Every Breath You Take," as you leave this conference today, I invite you instead to recall Marianne Faithfull's broken English and ask, what are we fighting for? Thank you.